Yes, Ayaz, over to you.
Uh, Good afternoon, everyone. I'm Mohammad Ayaz Raza in capacity of today's session moderator. On behalf of Faculty of Law, Integral University, Lucknow, and Law Teachers India, it is my privilege to welcome you all to the 14th session of second edition of 15-day online capacity building program on AI, technology, and law. Today's session focuses on the theme of immense contemporary relevance, the Digital Personal Data Protection Act 2023. We are delighted to have Dr. Deesha Khaire, an accomplished academician, researcher, and expert in the field of constitutional law, human rights, cyber law, as our distinguished guest speaker. Dr. Khare is presently serving as an associate professor at Maharashtra National Law University, Nagpur, having earlier contributed significantly at Gujarat National Law University, Gandhinagar, and other institutions with over 17 years of experience in academics and research. She has taught a wide range of subjects, including constitutional law, jurisprudence, human rights, cyber law, and biotechnology law, etc. A recipient of UGC JRF in human rights and duties, Dr. Disha completed her PhD at Pune University on Right to Health, a human rights perspective of HIV/AIDS patents. She has authored 3 books, contributed to 8 book chapters, and published extensively in a reputed journal. Her expertise extends to the policy research, where she has worked closely with the Dr. Gulshan Roy, National Cybersecurity Coordinator, PMO, and contributed to the project for the Supreme Court E-Committee, TARAI, National Commission for Women, and international collaboration with the Commonwealth Department, UK, and Victoria University, Australia. She was also the part of PMO New Delhi in a finding gaps and suggestion and recommendation relating to the Information Technology Act 2022, the amendment of 2008, and the Personal Data Protection Bill 2018. Dr. Disha has also served as a member of National Security Council Secretary Expert Group of Cybersecurity Law and has been a resource person for numerous government and private organizations. It is our honor to welcome you, Dr. Disha Khare. We are eagerly looking forward to your insightful insights on DPDP Act 2023, a subject of critical importance in today's digital age.
Thank you, Ayaz. And thank you very much, everyone, for having me today. I hope, Ayaz, my presentation is visible.
Yes, ma'am, it's visible.
Yeah, so at the outset, thank you very much, Integral University, Lucknow, as well as Law Teachers Forum. Thank you, Dr. Kalpesh Gupta. It's really nice to be back and get connected with you on this important topic. So basically, the topic that has been given to me to discuss with you all is the the DPDPA Act, in short, that is the Digital Personal Data Protection Act of 2023. I'll begin with the journey as far as this act is concerned, and the journey takes us all the way to August 2017. In August 2017, it is Honorable Supreme Court of India which declared right to privacy as a fundamental right as far as K. Puttaswamy judgment is concerned. Accordingly, in July 2018, a committee which was formed under the chairperson or chairmanship of Justice Sri Krishna ended up submitting report along with the draft of PDP Act of 2018. And then relating to again taking this whole journey towards having the DPDP Act of 2023. It is in the year 2019, and that too again in December 2019, the PDP, the Personal Data Protection Act of 2019, was introduced in the Lok Sabha and then was referred to the JPC, that is Joint Parliamentary Committee. Further, in December 2021, it took almost 2 years But then when you look at this journey, in December 2021, the JPC releases its report and then came up with a altogether new version of the Act as Data Protection Act. Taking ahead, then all the things which were happening relating to understanding and appreciating how and what the data is all about, personal data is all about, sensitive data is all about. We were continuously in the process of exploring and trying to have a proper, again, what you can say, legislation at place. So in November 2020, MITI, that is Ministry of Electronics and Information Technology, it released a draft Digital Personal Data Protection Bill for public consultation. In July 2023, Union Cabinet ended up approving this particular bill. Then in August 2023, the President of India finally gave assent to DPDPA Act, and then we have DPDPA Act of 2023. Currently, if I have to talk about again a recent development relating to DPDPA Act, then in January 2023, we got the draft Digital Personal Data Protection Rules of 2025, which was more to do with the operationalization of DPDPA Act. So in short, this is a journey which has started from 2017 and now we are in 2025. And there are a lot of changes that have happened when it comes to, again, the technological advancement, as well as the way we have been exposed to how data is being, again, looked into, considered as, and how data has also changed its size and shape. And thereby, it is important for us to look into as to what exactly is the current scenario when you talk about the data protection. And that too, again, when you say it is a digital data. So let us look into the applicability of the Act. Okay, so when you talk about the applicability, there are again things which are clearly been mentioned, wherein it clearly says that where and to what things it is applicable and to what things it is not applicable. So when you talk about DPDPA Act, basically it is about processing of what? Processing of digital and digitized personal data. So it is applicable to processing of personal data within the territory of India as well as outside India. So one can clearly see the territorial extent of DPDPA Act is extraterritorial. It is extraterritorial in nature. It is not limited to the territory of India. So any personal data which has been processed within the territory of India and outside India, this particular act and the provisions of this particular act will be applicable. Any activity which is related to, again, offering goods and services to data principals within the India is again something which is covered as far as scope of this particular act is concerned. To what this particular act does not apply. So when you talk about, again, processing of personal information, so processing of data for domestic or personal purposes by individual is something to which this particular act does not apply. At the same time, personal data which is actually been made public, to that also this is not applicable. Now let us look into the key terminologies that are being used when it comes to what? When it comes to this particular act. First and the foremost is consent. Now, how consent is relevant and in what sense this word consent or terminology consent is being used. So if you try to look into it, it is actually putting an obligation on the part of the organization who are into this business wherein the data of the individuals are being collected. So when you talk about consent and the way it is being used, and it is considered as one of the key terminologies of DPDPA Act, it is expected that the organizations, they should actually seek the consent. And this consent should be freely given, it should be specific, it should be informed. At the same time, it should be in an unambiguous way. There should be an unambiguous, I will use the word indication of the individual, or for that matter, the term that is being used for an individual or a user is data principles, wherein they are again giving a clear cut indication or consent or agreeing as to their data to be used. So when it comes to consent, basically, it is nothing but an obligation on the part of an organization that this consent must be free, this consent must be specific, this consent must be informed, this consent must be clearly mentioned without there being any ambiguity as far as the language is concerned. The second term that has been used is the consent manager. Now, who is the consent manager and what exactly is the role of the consent manager? So the consent manager actually is someone who represents the data principal. Now, who are data principals? Data principals are again, this is again one of the key terminology. So basically, data principals are nothing but the individuals to whom the personal data relates, okay? And it can again have categories such as a child, or wherein again, when you talk about child or a person with disability, then they have guardians who can then be considered as from whom their rights are being their rights are being protected or can be claimed. So basically, coming back to the whole terminology called consent manager, a consent manager is someone who represents this data principle, who can be an individual, who can be a child, who can be a person with disability, to whom the personal data is concerned with or related to. And then he takes action on the behalf of the data principles. And while again, when it comes to while granting, managing, or reviewing, or revoking the consent of the data principal. So the consent manager actually plays important role when it comes to when it comes to the consent that has been given by the data principal. Taking into consideration the next key terminology that has been used in this particular act is notice. Now, what and how notice is again mentioned in DPDPA Act. So here again, as it is in other statutes, when you talk about notice, notice is required to be again clear. There must be proper items which are being mentioned as to for what purpose it has been it is collecting the data, etc., etc., and the data should be, or the language of that particular notice is expected to be very, very simple. Here, with respect to data, DPDPA Act is concerned, here the data principles, they have the option. It is mentioned that they should have the option to access the information in any of the 22 languages which are mentioned in the 8th schedule of Indian Constitution. So what is it? The significant, again, point of consideration with respect to notice being one of the key terminologies as far as DPDPA Act is concerned, that not merely in English, but other languages which are mentioned in 8th schedule of India or Indian Constitution, it is what the data principal must have the access to that particular information in that particular or in those particular languages. The next terminology is about data fiduciary. Now, who is data fiduciary? Data fiduciary is any person who alone or maybe in conjunction with other persons actually determines the purpose and the means of processing your personal data. So he is someone who is considered again an important authority or important point of contact when it comes to, again, DPDPA Act is concerned, for the simple reason he has the power to determine the purpose and how the personal information is going to be processed. Now, again, when it comes to what? When it comes to DPDP Act, we have again data fiduciary, wherein again significant data fiduciary term is being used, which we'll discuss in due course. Now, let's talk about again one more important terminology, and that is processing outside India. Now, what is processing outside India? Processing outside, and how are we going to actually reach to the conclusion as to what exactly will amount to data being processed outside India? So herein, again, what has been expected, or why this particular terminology must be looked into and understood properly, is for the simple reason that the Act expects the central government or the government to notify which are all the countries to whom the data can be transferred, or for that matter, the transfer is not permissible. Okay, now this is something which is done in GDPR also, wherein they have used this whitelisting approach. Okay, so processing outside India, again, when you try to look into the clarity as far as this particular term is concerned, it is the government who is expected to actually share or the list of the country to which the data cannot be transferred or it is not permissible. Now, talking about data principle, it is again a key terminology which I've already explained. It is an individual or a child and a person with disability. And for two other, the child and the person with disability, it is the guardian who act on their behalf. So their personal data, their data that relates to these three are nothing but the data principles. Further taking ahead, again, we have something on the lines as far as children's data. So this is again one of the important terminologies which we must have a clarity, because there's little ambiguity with respect to again children's data and rights of children as far as DPDPA Act is concerned. So here when you talk about children's data, again, the age limit as far as DPDPA Act is, it is 18 years of age. So any child who is below 18 years of age, consent from his parents or guardians is required. And there is a strict, again, restriction or limitation, which clearly says that behavioral monitoring as well as targeted advertisements are prohibited when it comes to what? When it comes to children's data. Now, when it comes to trying to understand what exactly behavioral monitoring is, wherein a particular individual or a child is trying to what? Is trying to surf, or it is trying to search. So whatever he is searching from that, there should not be any profiling of that particular child to be made, and accordingly his behavior profile should not be made, and accordingly targeted advertisement should not be sent to that particular child. So that is something which has been prohibited. Talking about data processor, it is again any person who actually processes personal data, but on behalf of the data fiduciary. Then there is again one important term which we all must have clarity about, and that is the term that is being used is legitimate uses. Now, this is something which is related to the first term that or the terminology that I have discussed, and that is consent. Okay, so here when you try to talk about consent, consent and legitimate uses. Consent, how the consent should be? It should be free, it should be informed, it should be clearly stated, etc., etc. But when you talk about the things which are mentioned as far as legitimate uses are concerned, then consent is not expressly needed for those situations. Now, what are these situations? These are the situations wherein there is a disclosure by the data principles of a particular information voluntarily. So there wasn't any compulsion that he or she should disclose it, but there is a voluntary disclosure that has been done by data principle. There is again something wherein that particular data is required for the performance of a particular function under the law. It is required for medical emergency, among others. there is a need when it comes to that particular data that is required with any judgment issued under any law, if there is threat to the public health, or for that matter, when it comes to ensuring the safety in case of any disaster. So this is wherein we talk about the term that is legitimate uses, wherein you don't need consent of the data principle, and then gradually I mean, it cannot be challenged that I did not give the consent per se, or it was not a free consent or informed consent per se. So these are again the terminologies which one must have clarity when it comes to what, when it comes to DPDPA Act. Let us quickly look into one of the again important parts as far as the uh, DPDPA Act is concerned, and I'm going to deal with this in a very short manner. So anyone who's interested to know as far as the detailed discussion with respect to DPDPA Act, there are a lot of again materials which are available, which clearly has, I mean, lot of detailed discussion, provision by provision. The book that is, or the material that is available as far as DSCI is concerned, they have again material which has a clarity as far as what are the frequently asked questions with respect to again the different provisions of DPDPA Act is concerned. So there are a lot of materials. There's a lot of material which is available, which you can actually look into. So I'll be just dealing with the important parts as far as this act is concerned. So talking about the obligation on the part of fiduciary, data fiduciary, it is expected that they must engage with data processor in order to process the personal data on its behalf. And of course, this is something that they are expected to do through a valid contract only. So again, I'm sure those who are attending this particular session, they are aware about what is contract, what is valid contract, etc. What are the essential elements required when it comes to a particular contract to be a valid contract. They are expected to provide clear, concise, and comprehensible notice to data principals, as in what purpose that particular data is being collected, how it is going to be processed, and for what things it is going to be used. The data fiduciary is under an obligation to obtain a verifiable parent consent before processing children's personal data. So it is again an obligation on the part of the data fiduciary that they must seek a proper parental consent whenever the matter is with respect to children's personal data. It is expected that they shall actually abstain from processing personal data, which may result into causing harm to the children, or it may undertake the behavioral monitoring of children, or for that matter, there is a possibility that targeted advertisement can be directed to children. So it is their responsibility that they should see to it that such practices are not followed or are not resorted to by the organization. If at all there is any kind of what you can say breach, then it is the responsibility of the data fiduciary to actually report that data breach to the data protection board and the data principals. They are under obligation to delete and erase whatever the data that has been collected by them once the purpose is accomplished. So they should not be keeping that data with them, and should ask the data processors also to erase that particular data once the purpose is accomplished. At the same time, it is again necessary to look into this, that the data fiduciary is under an obligation to look into the implementation of the technical as well as organizational measures, so that they can ensure that the provisions of this particular act are being effectively adhered to by different organizations. as I've already mentioned that with data fiduciary, there is this term significant data fiduciary is also being used in this DPDPA Act. Now, what is this term called significant data fiduciary? So, see, data fiduciaries are again those who actually determine the purpose and process the personal data. But when it comes to actually understanding what data, I mean, significant data fiduciaries are, they are basically being determined. I mean, there are again parameters which are being used to figure out that whether a particular data fiduciary is a significant data fiduciary, and what are the assessments that are or parameters that are taken into consideration. First and the foremost, the kind of or the volume and the sensitivity of personal data that these data fiduciaries are processing. They take into consideration the risk to the rights of the data principle, the potential impact on the sovereignty and integrity of India, the risk to electoral democracy, public order, and security of the state. So these are again the parameters on the basis of which a data fiduciary then falls into the category of significant data fiduciary. And then further, when you look into the other provisions of this particular act, you will come to know that it definitely is connected as far as, again, in case there is any failure on the part of the significant data fiduciary or the data fiduciary, the penalty also changes. Okay, so there is a gradation when it comes to what? When it comes to the penalty that is to be paid by them. Let's quickly look into the obligations as far as the significant data fiduciaries are concerned. So they are under an obligation to appoint the DPO, that is the Data Protection Officer, who should be based in India. They are under an obligation to appoint an independent data auditor for evaluating the compliance of a particular organization or institute. At the same time, they are also having this obligation to conduct data protection impact assessment, which is in short called as DPIA, as well as periodic audit. So this is wherein one can see the difference as far as data fiduciaries and significant data fiduciaries. The role, the expectations of the functions are comparatively more, and of course, it calls for, again, in case there is a failure, there will be more of liability on the part of significant data fiduciary. Let's quickly look into the rights of the principal data principals. Now, who are data principals? It is we. Okay, it is the individual, it is the child, the one whosoever is using a particular, what you can say, service that has been provided by a service provider, whether that is, again, there can be different examples which can be given when it comes to the data principles. So, but in short, it is one who is using the services which are available in the virtual world. So first and the foremost, the few important rights of the data principles includes right to information. Now, what is this right to information is all about? So when you talk about this particular right to information, it is wherein this data principle, that means we have this right to seek the information on how our data is going to be processed. And here again, this particular act clearly says that how it is going to be processed, this must be explained in a very, very clear and understandable way. And that is wherein we talk about right to information of data principle. Okay. So wherein he has or he should have the right to seek the information from the data fiduciary, processors, etc., with respect to how it is going to be processed. Then comes your right to nominate. Now, right to nominate is wherein individuals can actually nominate any other individual to exercise whatever the rights that the data principal has in case of, say, death, or in case of any kind of incapacity. So that is also something which has been included in DPDPA Act, which is again can be considered as one of the important rights, because it's not that with death everything ends in virtual world. I mean, we all know that when it comes to even real world, uh, rights, liabilities, all these things do not end with the death of an individual. And same is the phenomena that is applicable when it comes to virtual world also. So this is something which is considered as one of the important rights which is covered in DPDPA Act. Then right to correction and erasure. So it is wherein we have this right to correct any inaccurate or incomplete data, as well as we have right to erase data which is probably no longer required for processing. So that is again, here again, it's very important right, as far as data principles are concerned, that we have this right to correct the information, as well as asking them to erase, remove it totally. The one more important right that the data principles have and is being recognized by DPDPA Act is about right to grievance redressal. Now, when you talk of this here in, it is basically, it can be said that the individuals have this right to register a grievance with respect to whatever the rights which are being what infringed by the organization. So where do we approach? We approach the data fiduciary. Okay, so we can register a grievance with data fiduciary with respect to, again, the procedure that is being, or the means that are being made available by that particular data fiduciary or organization and institution. Now, here, when we talk about the right to grievance redressal, unfortunately, timeline to respond to these or these grievances, which are raised by the individuals, or for that matter, data principals, that is not mentioned. So it is again the central government which is expected to notify as to within what time frame these grievances must be entertained by the data fiduciaries. Let's quickly look into what exactly do we mean when it comes to personal data breach. So personal data breach is again something, so data, this DPDPA Act, it revolves around personal data breach, okay? So there are, again, when you talk about data, you have data, simple data, you have personal data, you have sensitive personal data, you have critical information, etc., etc. But for the time being, let us try to focus with respect to personal data, right? Now, what exactly personal data breach means, and how it results into, again, bringing this whole act into force. Okay, so here when you talk about personal data breach, it can result into someone is stealing it by compromising a particular, what you can say, a system, a particular software, etc., etc. There are ways and means which are happening these days wherein the data is being wherein the data is being stolen. Okay, so here when you talk about the personal data breach, the data fiduciary is actually under an obligation. So the data fiduciary is basically required to protect our personal data. Uh, and it includes within it the scope or ambit of the, or the duty of the data fiduciary to processing which has been undertaken by it, or for that matter, on behalf of the data processor. So it is basically to look into the reasonable security safeguards that should be there in order to prevent a personal data breach. So if these are not there, then it is the responsibility of the data fiduciary to to protect it. In event if the personal data breach happens for some reason, which are happening quite frequently these days, it is the data fiduciary who needs to notify the data protection board and the data principal. So it is expected that the data principal should also be informed about the breach that has happened. Unfortunately, there is no specific timeline for reporting the breach. So this is again one of the lacunas which can be considered as far as DPDPA Act is concerned. And it is expected as far as the information regarding breach is concerned. So there's a proper format which should be followed by the data fiduciaries, informing as to when the data breach has happened, why it has happened, and how many of them are impacted, and what are the security practices, procedure that are being followed, etc., and when and whether it is been fixed or whether it is still vulnerable. So all these details are required to be mentioned in that particular format. So this is with respect to, again, preventing any breach relating to personal data and the obligation on the part of the data fiduciary. Let's quickly look into the different penalties. So as far as penalties are concerned, we have again 10,000 rupees, up to 10,000 rupees. There can be a penalty if there is a breach in observance of duty of the data principal. Then we have again penalty as up to the, I mean, quite a big number amount, that is 200 crores rupees in case there is a breach in not giving notice to the personal about the personal data breach. Okay, so it is either you are not informing to the data principal, or to the, you're hiding that particular information. So if you're hiding that particular information, then you will be liable to pay the penalty, which is as good as up to 200 crores rupees. Then again, there is this I mean, the same amount is there when it comes to, again, breach, when it comes to observance of additional obligation in relation to the children. So whatever the precautions that are expected to be observed, whatever the what you can say, safety measures or security measures which are expected to be taken with respect to safeguarding the data of the children, if there is any kind of breach, then the amount of penalty can go as high as that of 200 crore rupees. And if there is non-compliance of provisions by the data fiduciary, then the penalty can go up to 250 crore rupees. Let's quickly look into something which is, again, which is going to play an important role, and that is the Data Protection Board. Now, here also, when you talk about Data Protection Board, it is the central government who is expected. Okay, so the central government, it is going to do this by, again, a notification. So they'll appoint, they will establish, and this data protection board is going to be, or is considered to be, an independent board. Okay, and this is again for India per se. Okay, so this again should consist of chairperson and other members who again should be appointed by the central government. It is again what exactly are the tasks which are entrusted on the data protection board, that is DPB, is that task of enforcement, which includes again determining the non-compliances, imposing penalties, for that matter, issuing directions, and I mean, if there are again issues relating to dispute between the parties, then definitely the whole responsibility will be there on DPB in order to mediate between these two parties and ensure compliance with the law. At the same time, when you talk about what are the powers of this particular board, so the powers are similar to that of the powers of the civil court, and any decision or any appeal against the decision as far as DPB is concerned, then that appeal would lie before TDSAT, that is the Telecom Dispute Settlement Appellate Tribunal. So this is basically as far as the mechanism when it comes to what redressal mechanism. What exactly is the impact of this particular new legislation with respect to the laws which were already there? So let me bring this to your kind attention that before DPDPA could come into existence or became a law, it was Information Technology Act of 2000 and Amendment 2008, which was taking care of, again, what you can say, the matters relating to personal data, sensitive personal data, etc., etc. And not only these two, again, the particular statute, but with this again, in 2011, many rules were passed as per the provisions of this 2000 and 2000 Amendment Act, which further included the security policies, practices to be followed by the organization. So rules of 2011. Then there are intermediary guidelines wherein again an obligation was there on the part of intermediaries as far as protecting or safeguarding the data that has been collected. So this is something which is again what which was taken care to a great extent by the Information Technology Act of 2000 and 2008 amendment. Now in 2008 there was this act which was this 2000 act was amended and article 43A was added. Now this is something which was relating to compensation for failure to protect the data. Now, this is something which is now omitted. At the same time, when you talk about Section 8 1J of the Right to Information Act of 2005, it is amended to the extent of exempting the personal information, which actually allows the disclosure of that particular information in or for public interest. So this is wherein we talk about the impact of the current legislation on the already existing legislation. Quickly looking into the what you can say highlights of this particular act is wherein the central government has this power where it can by notification exempt certain provisions of the act to be applied as far as data fiduciaries or class of data fiduciaries, including startups. So this is again, of course, the volume as well as the nature of personal data that is involved will be looked into. So that is again one of the important again provisions of this DPDP Act is there. Talking about one more again highlight of this particular act is when the consent is being processed. So when consent for processing personal data is being provided, or rather it is before something wherein the commencement of this particular act is concerned. Okay, so if the consent for processing personal data was provided before the commencement of this act, then with this particular act, it was necessary that the data fiduciary needs to provide detailed privacy notice describing the personal data collected and the purpose for which it is going to be used. And this they are expected to do as soon as possible, as soon as practicable for them immediately after the enactment of this particular what you can say act is concerned. Then as I've already told you that there are certain provisions which are actually not applicable, will not be applicable for processing the personal data in India if of a data principle if it is not based in India, and that is again subject to the contract that has been signed with a person outside India. At the same time, again, an important power is vested with the central government, wherein the central government, once it ensures itself that if the processing of that particular data is verifiably safe, notify the age above which a data fiduciary shall be exempt from applicability of children's personal data obligation. So that is again wherein the central government can definitely actually exercise this power and exempt data fiduciary with respect to processing the data of the children's or the kids. Then you have again data principle. They are actually expected to exhaust the opportunity of redressing their grievance first with the data fiduciary, and then they can move on to the Data Protection Board of India. So these are again what you can say the key highlights of this particular statute or legislation. Quickly looking into the different kind of exemptions. Now, when it comes to what? When it comes to exemption, DPDPA Act definitely exempts whom? The data fiduciary from certain obligations. Okay. Now, it is again wherein the conditions should be clearly on the lines which are mentioned in the act. Okay. So whenever you talk about processing a particular personal data, data fiduciary will be again exempted from its obligation with respect to if the processing is for enforcing any legal right or claim, if the processing is for performance of any judicial or quasi-judicial functions by any Indian or say court or tribunal or other body, if it is in interest of prevention, detection, investigation, or prosecution of any offense of any law, or for that matter, the whole processing of data principle outside the territory of India, which are again pursuant to what I have already told you, that the contract that has been entered into with any person outside the territory of India by again a person who's based in India. So that is wherein again there is an exemption with respect to again what? With respect to obligation on the part of data fiduciary. At the same time, if the processing of that personal data is necessary for merger, amalgamation, or similar arrangement as approved by the court or other competent authority, then also the data fiduciary is exempted from this particular from the obligations which are on it with respect to again taking reasonable security safeguards, etc., etc. Taking ahead the discussion, let's quickly look into the ambiguities as far as this particular act is concerned. First and foremost is there is no clarity with respect to children's data. So when you look into the words which are being used with respect to children's data, there is this word detrimental effect on the well-being of a child. So this is something which is not being specified as to what will amount to a situation wherein the processing of the data of a child will result into giving a detrimental effect to the well-being of a child. So that is something which is not clear. So there is a lot of ambiguity as far as detrimental effect on well-being and then the processing. Next is about the breach notification. Again, as I've already told you that when it comes to the timeline, there is nothing with respect to the timeline. So this absence of again defined timeline with respect to again whether it is notifying the personal data breach to the data protection board or to the again affected data principals are concerned, this further results into again lot of scope as far as chances being manipulated, delay being there, and may result further into again what you can say complications or complicated situations. Then there is something on the lines as far as publicly available data. So again, when you talk about this particular term, this act actually exempts any personal data which is made publicly available, but it does not actually, unfortunately, clarify if the information which is made available to the public can be used for processing, or whether it can be used only for the purpose of viewing it. I mean, you just view that particular information and forget, and then you cannot use it for any other purpose, or you cannot not process it. So this is again somewhere one needs to have clarity, else this particular ambiguity further may result into a lot of interpretative, again, challenges. And again, timeline is again something which is what you can say, an issue wherein there is no clarity as to, once a matter is being taken by the data principal with respect to infringement of their rights, violations of their rights, etc., to the data fiduciary, within what time they should respond to. So this is again one of the ambiguities as far as DPDPA Act is concerned. Now, I'll quickly take you to the what you can say, a kind of comparison with respect to GDPR and DPDPA Act. So, trust me, when it comes to again DPDPA Act, many of the provisions are on the lines as far as GDPR is concerned. But however, there are differences also. So when you talk about the application of GDPR, it applies to processing of personal data either wholly or partly by automated means, and to personal data which either form or will form a part of filing system. Now, this is when it comes to what automated means, or to personal data which is either already form of or will form a part of filing system. When it comes to applicability of DPDP Act, it will apply to whom? It will apply to digitized personal data, and at the same time non-digitized personal data which subsequently will be digitized. So this is wherein we talk about the applicability and the again nature of the data. Penalties, as far as GDPR is concerned, it extends to 20 million euros, or 4% of the firm's worldwide annual revenue from the preceding financial year, whichever again amount is higher. As far as penalties under DPDPA Act is concerned, highest is like 250 crores. Then comes your, what is the status or the age as far as minors are concerned. So 16, wherein you need anyone who's below 16, you need parental control. There are certain member states of Europe wherein this age can be lowered below 13 years also. As far as India is concerned, it is 18 years. When it comes to GDPR, whatever the breach is there, it should be notified to the supervisory authority within 72 hours, and possibility to the affected data subjects also. Here, unfortunately, there is no specific time frame for notification with respect to personal data breach. It does not include, GDPR actually does not include right to nominate. However, it provides for right to portability. Okay, so you can port your data. So organizations on the request being, I mean, received from the data subjects, they have to respond within 30 days when a data subject is requesting to port. So transferring from one to other organization. As far as DPDPA Act is concerned, it actually, again, what it has given this right to nominate. Okay, so the data principals have the right to nominate, while it omits, it does not recognize right to portability, and there's no timeline to respond to again data principles request has been specified. GDPR actually lays down a specific mechanism for transferring data to third country, such as again standard contractual clauses and binding corporate rules. Whereas when it comes to what? When it comes to Indian personal data protection legislation, it is what? It is wherein the act actually lacks any such what? Any such uh, expressive provision or express provision with respect to what? With respect to transfer mechanism for transferring the personal data. GDPR, both controller and processors are under the obligation to appoint DPO in specific circumstances. Here, when it comes to DPDPA Act, only significant data fiduciary shall have to appoint DPO as a point of contact for Data Protection Board. So this is again one of the important difference when it comes to GDPR and DPDPA Act. As far as data controller and data processors are concerned, they are required to maintain the records and all the processing activities. ROPA is something that is what it is being termed in the language as far as privacy professionals are concerned. Unfortunately, our DPDPA Act does not include any such obligation on the part of data fiduciary wherein they are required to maintain ROPA, that it is, they are required to maintain record of processing activities. Further, I think GDPR does not explicitly specify in which language the notice is to be provided. DPDPA Act clearly mentioned that all the, I mean, Indian languages which are mentioned in the schedule of Indian Constitution, in those languages, the notice must be given. When it comes to data protection impact assessment, as far as GDPR is concerned, it is to be conducted by data controllers for all the high-risk processing activities. In India, it is this significant data fiduciary who is under an obligation to actually conduct periodic data protection impact assessment. So these are basically the, what you can say, important differences as far as GDPR and DPDPA Act is concerned. Similarities are actually many. Many of the provisions as far as DPDPA Act is concerned, they are being taken from GDPR. Looking quickly into the compliance mechanism. When it comes to the compliance mechanism, basically it can be looked into and there are multiple facets and requirements wherein it can be phased into something from the 3 months to 25 months for in order for a particular organization or an institution to effectively actually look into the sustainable data privacy and protection programs. So when it comes to 3 to 6 months, they are actually expected to undertake data privacy assessment to understand the current posture towards privacy and requirements. They're expected to develop their data privacy framework to strengthen their organization, whatever the data privacy program that they intend to have. They should have the data. They must establish the data privacy organization to drive that particular program. Data discovery, classification, mapping exercises to identify the personal data touch points, structured and unstructured data across the environment, and then further classifying it, then developing an inventory of assets, processing personal information. All these things can be done if an organization is in process with respect to, again, complying with the provisions of the DPDPA Act. So this is something which they can do in the initial first 3 to 6 months of their organization. In next 6 to 12 months, they can actually conduct the data, what you can say, privacy impact assessment for high risk in scope business functions. they can develop and update actually the whatever the relevant what you can say process or underlying procedures that they want to follow when it comes to what, when it comes to their again the business activities are concerned. They are expected to establish mechanism for consent management, data principal rights, and breach notifications. In another like 1 year to the second year, they are expected to implement the privacy. PET is something that is privacy enabling technologies, so that they can reduce the manual task and manage their data governance activities in an automated manner, as well as they are actually expected to undertake the external what you can say certifications from the different organization in order to demonstrate that they have done the compliance towards the privacy information management system. So that also will work in favor of the organization, and that will further result into safeguarding and protecting the personal data of the individuals. So basically, in conclusion, if I have to talk about what this whole DPDPA Act is all about, and what are the important points. So basically, it mandates explicit consent, it defines data rights, it institutes security measures, it protects children's data. Further, it is something because of which there is going to be data protection board, again in order to safeguard our interests, protect our data. It talks about cross-border and sector impact. It is again about penalties, which are like heavy penalties. And there are again graded responsibilities. So again, those who are dealing with high risk information, uh, 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 they are being expected to uh, look into and have lot many obligations as compared to startups or the small scale industries are concerned. So in short, this is again a legislation which again in initial stage definitely is going to have a not very easy probably a journey when it comes to its implementation, but gradually I'm sure we'll all get used to, and we will look into as to how the personal data can be protected, how the information can be protected. So I guess I'll stop here. Thank you.
Thank you so much, ma'am, for that insightful lecture. Now we are further proceeding to the query section, query part of this session. Ma'am, there is a query: who train the auditors? What are the qualifications and what are the exams which are for the auditor? And is there any published list of auditor?
Auditor. So basically, I mean, if you look into these days, the Data Security Council of India, it is actually conducting different certification programs. Okay. So you have certificate program for the data protection officers. You have again the impact assessment officers, DPOs, and these certifications are again offered by DSCI. They run on a regular basis, and if you have these certifications, again the additional certification, as in the additional qualification probably is, if you have a background of law plus technology, then it will be better, it will be beneficial, because these are again certain what you can say jobs which will be in demand soon. So extensively, people are getting the certifications for this, and then accordingly, abhi internally what is happening is that these organizations internally are only sending their officers to seek those certification and get themselves certified and take care of all the breaches, etc., etc. The organizations or the institutes are expected to display the list of the auditors of that particular organization as to my knowledge, there is no repository as far as India is concerned. To my knowledge, there is a possibility that probably by now they must have had, okay, created. But I encourage the participants to actually look into these courses and go for courses which are offered by the government agencies, okay? Because then the authenticity of it is taken care of. So there are many, again, courses which are offered by DSCI. Those who want to get into the international privacy sector, I encourage them to take up the certifications as far as IAPP is concerned, International Association for Privacy Professional. I have myself cleared this certificate in international privacy, so professional. So I'm qualified to be a privacy professional for European countries. So little expensive, but yes, worth doing it. So yeah, go for all these examinations. This is a sector wherein a lot of demand is soon going to be there. There are banking organizations which are now calling for data controller, data auditor, impact assessors, etc., etc. So these courses can be looked into. Yes, I asked.
Ma'am, that was the only one query. So now I'll go to the end of the session. On behalf of Faculty of Law, Integral University, and Law Teachers India, I extend our sincere gratitude to our esteemed guest, Dr. Deesha Khaire, for her enlightening address. Her comprehensive analysis of DPDP Act, combined with the vast academic and policy research experience, has been given a invaluable insight into the future of data protection and privacy and governance. I also thanks to organizing committee and faculty members and technical team, those who have dedicated to assure the successful session. Most importantly, I thank all the participants for their keen interest and thoughtful presence. So thank you all for attending the session. See you in the next session. I conclude.
Thank you,
Thank you
Aya.
very much, madam. Look forward to see you. Thank you.
Yeah, thank you, Kalpesh sir, and thank
Thank
you,
you.
Integral University. Thank you.
Thank you.